One of our diagnostic pathologist doctor got later are approached by this TPA guy on a report what is signed on a digital form. Because across cities, if you find pathologists are attached to multiple lab, and since they cannot physically present, they give a digital signature to them or a physical signature to them. And questioned about digital signature. Also, in investigation, they have found that some report was already given by the pathologist, but which was not known to this MD path whose digital signature has been used. And they wanted to make a ground to reject. So they threatened such a doctor that they will file a case in medical council. They will file a case in various other places. They will see that the registration can be stayed. By all sort of a pressure creation to these doctors, they take in writing from the doctors that they were not aware about this or not allowed any lab to use their digital signature. And that is enough for them to reject the claim of claimant. And then next, they will show this paper to the court that this doctor has said this, that's the reason why they have rejected. And it will bounce back to the hospital because the insurance claim done by the patient against the insurance company, if not been fulfilled, that the same patient goes in a court of law, make hospital, doctor as a party and insurance company as a party. For him, it is important to get a claim. If it is the fault of a doctor, the doctor need to pay or hospital need to pay. If it is the fault of insurance need to pay. These are the tactics used by this insurance company, and that's the reason why they send you lots of notices just to get your admission or not. Many of the time, vendors and other people also send the notices. Patient very commonly send the notices. So we need to be very careful how and what we need to answer to any notices which you receive by your client. One thing, please remember on a law point, which you can tell to every client you wish to, that you are not legally bound to answer every single notices of advocate or any person. But many of the time your client do want to keep something on record. You can advise them, yes, just to keep on a record, we can answer the notice. But it's not legally bound. Your client may get frustrated if within 7 days you don't answer. They will call you many of the time that notice written that within 7 days need to be replied, within 3 days need to be replied, within 5 days need to be replied, within 8 days need to be replied. So your client does not know the law, so they get frustrated. But it is not mandate to reply within 7 days or 8 days. Rather, it is not mandate to reply advocate notices or common people notice. But you cannot avoid the answer to any authority's notice. Let it be a medical council notice or consumer court notice or any other authority. Their notices you are bound to reply. There is no option for you. But in my opinion, it is better to reply every single notice. Because if you reply to every single notices, it creates the ground and record for future defenses of theirs. So this is the first thing which you all remember every